Statutory rights of the accused, meaning everyone is given a fair trial as the law stipulates. Statutory itself is the permission or granting. In other words, statutory rights are the enactment of rights provided by the state or government. An accused in a criminal proceeding has entitled right to defend himself in the court.
Under Section 1 Rights of the Accused of Rule 115 to be informed of the nature and cause of the accusation against him. This entitles the defendant to be informed of the crime charged against him. The indictment should contain the allegation with a clear description. An accused person has the right to know what charges have been filed and have the access to all or any evidence that gathered against him. It is a protection of constitutional rights under the 6th Amendment. It is designed to make sure that the accused person shall receive a fair trial.
To be present and defend in person and by counsel at every stage of the proceeding, from the arraignment to promulgation of the judgment.
Testify as a witness in his own behalf, but subject to cross-examination on matters covered by the direct examination. Testimony of the accused in his own behalf can be submitted in the court trial, however, bound for cross-examination. The consistency of the statement must be observed to decide the case rightfully by the court. In criminal proceedings, the defendant refers to silence himself that cannot be used against him in any manner, unless there is a place of solid evidence presented in the court that points all the aggression during the arraignment.
According to the Rule 115, Section 1 Rights of the Accused, his silence shall not in any manner prejudice him. It means if the accused decides to remain silent, the judge and jury must not interpret this as a proof of his guilt. Though he is remaining silent, he still have the chance to be heard by the court. In the latter part, the accused will presume innocent until the contrary is proved beyond a reasonable doubt.
The 1987 Constitution, in Article Number 3, Section 17 provides that no person shall be compelled to be a witness against himself. Also, under the rules of criminal procedure, particularly Rule Number 115, Section 1A, an accused on trial is exempt from being compelled to be a witness against himself. The phrase self-incrimination does not appear. Likewise, self-incrimination is not used in Article Number 6, Section 21 of the Constitution in reference to inquiries in aid of legislation. Section 21 provides that the Senate or the House of Representatives of any of its respective committees may conduct inquiries in aid of legislation in accordance with a duly published rule of procedure. The right of person appearing in or affected by such inquiries shall be respected.
To confront and cross-examine the witnesses against him at the trial, to light as part of its evidence the testimony of a witness who is deceased out of or cannot with due diligence be found in the Philippines unavailable or otherwise unavailable to testify given in another case of proceeding, judicial or administrative involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him.
According on revised rules on evidence, Rules 128 to 134, Rules of Court, Rule 128, Section 1, Evidence Defined, sinasabi lamang sa Section 1 na ang katibayan ay paraan ng pagtiyak sa judicial proceedings na nagbibigay katotohanan hinggil sa isang bagay. Section 2, sinasabi rin na kailangan ang lahat ng ebidensya o katibayan ay pareho sa lahat ng pagdudulog at paglilitis sa anumang hukuman. Section 3, Admissibility of Evidence, sinasabi sa Section 3 na anumang katibayan na may kinalaman o kaugnayan sa issue ay katanggap-tanggap. On the other side, to have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf, the court may seek jurisdiction over an individual, or meaning the court exercises jurisdiction to compel an individual to make an appearance in the court of law. The court may issue a subpoena and arrest warrant to call out the witness. Sinasabi lamang dito na may karapatan at jurisdiction ng korte na ipilit, maipakita o mairepresenta ang tao sa hukuman. Kinakailangan ng korte na maglabas ng subpoena at arrest warrant para anyayahan at tawagin ang isang witness.
An accused's right to have speedy, impartial, and public trial is guaranteed in criminal cases by Section 14 of Article 3 of the Constitution.
To make an appeal in all cases allowed in the manner prescribed by the law. One of the rights of the accused are right to make an appeal. If the accused has been indicted to his or her crime, he or his family member may file an appeal to the higher court if they think that the lower court decision is injustice or made some legal errors that affect the judgment. Then, the Supreme Court is going to review all the evidence that is presented and given by the prosecutor to the lower court. And depending on the Supreme Court decision, the case might be set aside or order a new trial to make the judgment right. But take note that the appeals are rarely successful.
Custodial investigation is any questioning by law enforcement after a person has been taken into a custody or otherwise deprived of his freedom of action in any significant way. It refers to the investigation conducted by law enforcement immediately after arrest of the commission of an offense.
According to Republic Act 7834, which enumerates the rights of persons arrested, detained, or under custodial investigation, any person arrested, detained, or under custodial investigation shall at all times be assisted by counsel. It means that the presence of counsel or an attorney should be there to assist the person arrested, detained, or under custodial investigation. On the other hand, if a public officer or employee or anyone acting under his order or in his place arrests, detains, or investigates person with regard to an offense he has committed, that public officer should inform him about his right, such as the right to remain silent and the right to have counsel or an attorney, preferably of his own choice. Take note, if the person cannot afford to have his own counsel, the investigating officer is the one responsible for providing that person a competent and independent counsel.
The custodial investigation report shall be reduced to writing by the investigating officer, provided that before such report is signed or thumb-marked, if the person arrested or detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or the assisting counsel provided by the investigating officer in the language or dialect known to such arrested or detained person. Otherwise, such investigation report shall be null and void and of no effect whatsoever.
According to the Section 3, Rule 1.3 of the Rules of the Court, extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of force hostility. Extrajudicial confession of the accused in criminal cases are universally recognized as admissible in evidence against him, based on the presumption that no one will declare anything against himself unless such declarations were due. Accordingly, it has been held that the confession constitutes an evidence of a high order, since it is supported by the strong presumption that no person of normal mind would deliberately and knowingly confess to a crime unless prompted by true conscience. Take note that extrajudicial confession is any admission or confession made outside the court. That any extrajudicial confession without the presence of his or her counsel or any of the parents or legal authority in the absence of the latter shall be inadmissible, as well as the confession that is not done in writing will be considered as the hearsay. If the arrested person is illiterate or has incapacity to read and write and silence the waiver, it is advisable to use his or her someone. And lastly, the confession must be voluntary and done without any violation of the arrested person's rights for it to be admissible as evidence in the court.